Mayor.
Yes,
Item number 6, my lord.
6,
Yes, my lord.
CRP.
Yes, my lord. I'm not prepared in this case, my lord. Can it be listed after 2 weeks, my lord? I've taken the consent of the respondent.
Okay. On the prayer of Mr. BP Learned Counsel to the petitioner, list this matter after 2 weeks.
My lord. Obliged, my lord.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention one unlisted matter, Lordship.
What is
This
the
Lordship,
urgency?
CRP, Lordship.
What is the urgency? Tomorrow.
Lordship, for withdrawal, Lordship.
Withdrawal.
Kindly, this matter may be taken up tomorrow, Lordship. Obliged.
May I please?
Yes.
My lord, I beg to mention item number 4. On the instruction of leading counsel.
Item number?
Item number 4.
Item number 4.
Yeah. As the leading counsel is out of station on medical ground.
Who is your leading counsel?
KK lawyer.
Yeah.
So I
the
kindly
prayer
pray
of
for
the-
the matter will list after puja vacation.
On the prayer of Mr. Otherwise, this matter before any other appropriate bench without me. Not
Much of-
before me. Hmm.
May I please, my lord? But I beg to mention item number 19.
19.
Yes, my lord. Here in this matter, my lord, I have supposed to file additional affidavit by annexing separate affidavit of petition number 2 and 3.
Techi
So-
boy.
Yes, my lord.
Why not Techi man?
My lord, petition number 2 is residing in Assam, Dhemaji. So due to changing of his mobile number, I could not able to contact him. So I need time.
Petition number 2.
Petition number 2, yes.
Okay.
2 and 3 is
The
supposed
prayer
to
of
file.
Mr. N. Rama, learned counsel for the petitioner, list this matter after 2 weeks.
After vacation.
After 3 weeks.
My lord. Much of it.
My lord.
Yes, yes.
My lord, I beg to mention item number 5,
5.
7 and 8 on behalf of helper.
Different orders, my lord.
5,
7 and 8.
7 and 8. Why? Listing premise is not there.
My lord, the council do not prepare.
Huh?
The leading council do not prepare.
Where he is? Where he is?
Yes, in another court.
Okay. So I
Trial
could
court.
not prepare.
Yes, sir.
Mr. So-and-so, learned counsel for the petitioner. Item 5, huh?
Yes.
Learned counsel appearing on behalf of Mr. L. Perme.
My,
Press for adjournment of this matter
my
on
lord,
the ground that the leading counsel, Mr. L. Perme, could not prepare the matter for argument today.
my lord, matter may be
Yes.
listed after puja vacation.
Uh, the prayer not being opposed by Mr. Deepak, learned counsel for the respondent.
I'm only in 5.
Yes, I think I'm on item 5. Huh? Let this matter be listed after 6 weeks. 6 weeks.
No, my lord.
No, no.
it will be reg-
Puja,
This is a
puja
case.
vacation.
After
I
three-
wanted to
six-
argue it all along, my lord. This is a case.
No, I
that,
thought this court is also thought of disposing to
because this is a case where they have done something unbelievable.
that exhumation.
Yes. Now they are taking time all along. This court at one point of time was about to dismiss this case. There after time.
Anyway. Then in that case, after 3 weeks. Then similar
Except
prayer, but in item
And-
7 and 8.
18. And my lord, item number 10.
Not,
also.
not in that case, he's not there.
Item 10, my lord, next week. There's an urgency.
Item 10 also.
Yes, they are great.
Yes, sir.
Item 10, on the prayer, Mr. So-and-so, learned counsel appearing for Mr. L. Perme. And agreed to by learned counsel for petitioner Mr. Deepak, let this matter be listed next week. Next week.
Joseph, I beg to mention item number 31. Also.
31.
Kindly it may be taken up tomorrow. I have taken consent from the additional.
31.
31.
Not tomorrow.
Tomorrow.
Not tomorrow.
Very limited,
Then after, huh?
very limited.
I don't
Only the
know.
interest part.
Huh?
Only the interest part.
We don't know. Let's see. On the prayer, Mr. S. Tafiq, Land Council for the petition. 31, huh? List this matter tomorrow,
Close.
18/09.
Lordship, I'd like to make item number 25, 26, Lordship, to the supplementary heading. Lordship.
25, 26.
Lordship,
Yes,
Lordship, today only I have received the, this brief, Lordship, so it may be listed, Lordship.
it's of 2018 matter.
Lordship,
How can you receive the brief today?
Lordship, actually, we file endorsement, Lordship, so for the file endorsement, Lordship. So it may be
This
listed
morning or yesterday?
in morning, Lordship.
Why? You don't distribute the file in the
No.
next day, one day before?
Lordship, actually,
This is given to, given in the morning.
Lordship, the file endorsement, Lordship, it is, has to be done, Lordship, in the evening, Lordship, so this morning only I have received. So it may be listed, Lordship. Tomorrow also, Lordship, I have no problem, Lordship.
24 or 25.
Okay. On the prayer of MS L. Hage, London additional PP. Comma. Comma. Stating that the briefs together, briefs have been, a brief have been, on the prayer, so and so, comma, brief being endorsed this morning, comma. She could not prepare the matter. Therefore, phrase for listing the matter. After a week,
It will be on 24 or 25.
on the next listing, on the on agreement, on the consent of the parties, let this matter be listed on 25/09/2020.
May I, my lord?
Yes,
My lord, I beg to mention item number 18, my lord.
18,
Yes, my lord.
yes,
My lord, I need some more time to file my reply, my lord.
on the prayer of Mr.
NUV, my lord.
Learned Counsel for the petitioner.
No, my lord, respondent, my lord.
A respondent, let this matter be listed after 3 weeks, so as to enable the respondent number,
All the respondent, 1 and 2.
so as to enable the respondent to file the counter affidavit.
Obliged.
My lord, my lordship, I beg to mention item number 13.
13,
Yes, my lord.
1 3,
Yes,
yes.
yeah, my lord, my leading counsel is out of station. So, my lord, matter may be
On
listed
the
after 3
prayer of
weeks.
Mr. So-and-so, learned counsel, who submits that his leading counsel is out of station,
Yes, my
and
lord.
therefore press for listing the matter after 4 weeks,
3 weeks, my lord.
3 weeks, list of. Prayer not, prayer accepted, let this matter be listed after 4 weeks. 3 weeks,
Yes, my lord.
same thing, 4 weeks, 3. Yes,
My lord, I beg to mention item number 29 and 30. In item number 29 and 30, the party have settled the matter. So the petitioner has instructed me to withdraw the case.
29,
Petitioner.
yes.
29, 30.
Mr. T. Sunil, learned, T. Sunil,
Petitioner.
learned counsel for the petitioner, submits that the parties have settled the matter outside the court, to which Mr. Deepang, learned counsel, endorsed the same. Therefore, phrase that matter be closed. Next matter. in view of the submissions, no. Accordingly, the matter is still closed. Closed, the stands closed
Yes, my lord.
and disposed of. What did they disposed of?
May I, Lordship?
Yes,
Lordship, I would like to mention unlisted matter for withdrawal, Lordship.
yes,
So it may be allowed, Lordship.
yes.
Withdraw.
What's if we have changed the course title?
What do we have changed? Nothing. What do you have changed?
Nothing.
There's no change. What is the change, sir?
Lots of this case regarding 2020.
How you have changed it? What is the change? There's no change. I don't find any change. Which one you have changed?
Page number 1.
Page number 1.
Yes.
Yes. What is the difference?
Four 82 has been strike out.
What should be the provision under BNSS?
Your
What is-
lordship, corresponding section is 438.
This case of 2023.
Huh?
Case of lordship
When did you file?
we filed the
23rd, 13th of September.
3 days back.
Yes, 13th of September. You fell under the new act, that's all. That is what I have indicated yesterday. That is what I have indicated yesterday. This is an application before the High Court. 482, what is the corresponding? Under BNS,
Your lordship, 397 corresponding is 438.
then 482,
482 is
438.
528.
528.
Yes.
You correct that. That is what I wanted to correct.
All right.
List this matter again tomorrow. So as to enable the Mr. Tito, learned counsel for the petitioner to correct the course title. Should I mention particularly inserting the relevant provisions
All right, lordship.
of BNSS 2023? That is what I wanted.
All right.
Or Mr. T. Gatso, learned counsel for the petitioner. Applicant, this is an application under section. What is this? 483 of BNSS. Don't write BNS, huh? Write BNSS double S. 2023. Praying for. Praying for bail. Praying for release of the accused person on bail in connection with Sessions case number. What Sessions case?
Session case number 08 of.
08 of 2019. Under section 302, public 34 IPC. Where is it, which session?
Bombilla, lordship.
Before the district, before sessions?
West
Session
coming,
Judge, West Coming District, Bombilla. The accused person was arrested when?
On 20th, arrested on lordship, can come to page number.
Tell us the date of arrest. That's all.
The story is, lordship, it's like this, lordship. He was,
Since when you are in jail
Yes.
continuously?
lordship, since 10
Forget
1
it,
of
forget it.
2024.
Forget it. Call for the case diary. No,
Lordship.
call for the
NCR, TCR, lordship.
trial court, scan copy of the trial court record from the Court of Sessions West Caming District, Bomdila. MS Swenso, London, additional PP appears for the state. List after? List on, Swenso next. When?
Lordship,
Somewhere 27, 28. Or else first of October,
26, Lordship.
1st of October,
26th of September, Lordship.
26,
Yes.
2609, 2020.
Obliged.
It is a criminal petition, filed under section 528 of the ENSSL. For passing of.
Heard Mr. Swenso, learned counsel for the petitioner. Petitioners,
Yes, Your Honor.
compromise,
Yes.
settlement.
It is jointly filed by the owner person,
Okay.
informant, active and executive.
Street fight. Huh? Street fight or bar fight? This is an application under section 520 of BNSS 2023. For quashment of criminal proceedings pending before the judicial magistrate first class, capital complex, UPA. In GR case number 160 of 2011
Yes, Your Honor. 11 cases.
under section 341/324. 341 and 324.
Yes, 341 is compatible, but 324 is not.
324 IPC. On the basis of compromise between the compromise by and between the parties. Listen. Call for the scanned copy of the year case number 160 of 2011 from the Court of Judicial Magistrate, Learned Judicial Magistrate, First Class, UPA. Next para. MS T at Learned Additional PP enters appearance on behalf of the state. Pending next para, pending production of trial court record, scanned copy of trial court record, the further proceedings of the GR case number 160 of 2011 before the Judicial Magistrate First Class UPA shall remain suspended. This after 3 weeks.
Obliged.
Madam, kindly pass on the pending.
Possible for the time being. This is what?
Lordship, kindly this matter may be passed over forever, Lordship.
Why?
Mr. Titangin tying is on legs at the court, number 1, Lordship.
Service completed. Heard Mr. T. Tai, Land Council for the petition, applicant. Come on. This is an application under section 5 of Limitation Act 1963. Rainfall. Condemnation of delay of 100 days in filing the connected MSC appeal 2022 of 2022. Next para. The service Learned Counsel Mr. R.L. Tungan has appeared on behalf of the respondent number 1. Mr. Respondent number 1 on 01/03/2023. However, no wakalat number, no power has been filed. Mr. Has on that. Next para. The learned constituent applicant has filed it. You have filed an affidavit.
Lordship.
Filed an affidavit of proof of justice service.
Yes, Lordship, I filed.
Filed an affidavit regarding the proof of justice service upon the respondent number 2 and 3, which is taken on record. Mr. Taken on, Mr. Therefore, the service upon the all the respondents are complete. Expect. What is the ground of delay?
Lordship, delay was caused due to the investigator, Lordship, report. The investigation report. It took a long time, Lordship.
Having considered the grounds taken by the applicant, I'm of the view that the applicant could. So the grounds taken, no, grounds for grounds in filing this connected appeal appears to be German listable. Accordingly, I deem it appropriate to allow this IA by condoning the delay of 100 days in filing the connected appeal. Accordingly, the application is allowed and the delay of filing the connected appeal, the delay of 100 days is condoned. Application is then disposed of, allowed and disposed of.
Lordship, in IA number 252.
What is IA?
IA 250, Lordship, we are seeking an stay of the exhibition.
Whatever, any notice? Oh. In IA 52. Heard Mr. Swenson, Learned Counsel for the applicant. Issue notice. No. This is an application praying for stay of the execution of the impugned judgment and order award dated 04/06/2024 passed by the Learned Tribunal, MSCT, Learned Member, MSCT, Bombilla, West Gaming District in MSCT case number 10 of 2021. Which is put to challenge, which has been put to challenge in the MSCT appeal 22 of 2022. Issue notice to the respondents returnable by 4 weeks. The applicant to take steps for service of notice upon the respondents. By registered post so and so within 3 days. Yes, yes. Where is that? You'll have to take press steps in appeal. Yes, because you have condemned it. Yes. The counsel by the petition, the appellant to take press steps for service of notice upon the respondents within 3 days. You take a step here also. This after 3 weeks.
Lordship,
Yes.
conducting counsel is out of session
Why?
due to his personal
Why? We should
difficulties.
wait for him to come back from the
So-
outside.
I may be allow more time to file an objection.
Last time also you have, this is the 3rd time.
I pray to continue for the meeting.
I have taken
Yes.
question others.
What?
Interim for
What interim?
stay.
What is stay? What is the matter? Who is seeking transfer from where to where?
My lord, from UPR to Teju.
Yes. Who is seeking the transfer?
The leading counsel is out of station.
Yes.
The leading counsel is out of station.
Then why you are asking for a stay? You are good at matter, will grant you. You are asking for a stay of the proceedings. Are you asking for this? Are you praying for a stay of the proceedings?
To continue the
Okay.
continuation of the.
There is already an interim order.
Yes.
Okay. So I thought you were asking for a stay of the.
No,
Mr.
Endoji.
Endoji, learned counsel for the respondents, press for further 3 weeks time to file objection to the transport petition. List of prayers allowed. List this matter after 3 weeks.
3 weeks.
So as to enable the learned counsel for the respondent to file objection. The interim order passed earlier shall continue. Before that, you just said.
Must oblige.
So and so, huh? Yes.
No, they respondents have filed their Wakalat.
Okay.
I talked to Mr. Sonar this morning.
Yes.
When it fixed for admission hearing after the petition.
Okay. Service you are appearing.
Yes.
Heard Mr. Deepang, learned counsel for the petitioner, and also Mr.
M. Kambo.
N. Kambo.
M. Kambo.
M. Kambo, learned counsel for the respondent. List this on the list the matter for admission hearing after puja petition.
Interim.
Interim order was earlier shall continue.
May Your Lordship,
Yes.
today this matter is for the submitting by the steps taken as affidavit. I already filed in the last month. In the records, it's clearly mentioned that 20 August 2024, wide publication in the two newspaper along with the WhatsApp recording. The steps already done, Your Honor.
You have
And
filed,
there is-
you have filed the affidavit.
yes, already filed, Your Honor. In the record also submitted through the registry. And the
Okay.
opposite party also
When did
appear.
you file it?
Yes, my lord.
When did you file that affidavit?
20 August, Your Honor.
Hmm?
20 August.
Yes, you are appearing for the respondent.
Yes, my lord.
All.
Only one.
Only one, Your Honor.
Only one.
Yes.
Yes.
Rest you have, how many respondents?
Only one, Your Honor. And then, Your Honor, in the last week, there is some complication, Your Honor, some mistakes in there, Your Honor. My associates came here to press that the steps already taken, but the
It's okay if he
Yes,
is
yes.
appearing, it's a sole respondent.
yes, all responded.
If he
Husband
is
and wife.
appearing,
Yes,
what's
yes.
wrong?
Your Honor, matter was like that.
Yes.
On last occasion, after knowing the notice published in the newspaper, we filed the Bakalatnama and he got the matter adjourned when we appealed. This is the matter. Today again, he has filed IA. So we do not know, even we haven't received the
IA for what?
I don't know. My-
IA for what?
I have for condolation of 4 days delay, Your Honor.
Huh?
Condolation of delay, Your Honor.
For
4
File-
days, 4 days of condolation of delay, Your Honor.
filing?
Filing,
Filing what?
filing of the civil revision petition, Your Honor. In this case, Your Honor.
Okay.
Main suit is different, I is different, Your Honor. Your Worship.
Okay, it has not been allowed. CRP. Okay,
My lord,
so you want some
just
time,
now I have received the
you want
copy of,
some time to file objection?
yeah, yes, your.
It's
Okay.
a 4 days delay,
No, this is a copy of the main petition.
sir.
Only today
It's
I.
only 4 days. 4 days only.
Only 4 days.
Anyway,
Due to the sickness of the council, Your Honor.
I have the copy. Yeah, I-
Already given.
My lord, we haven't received the
you go
Yeah.
through it, will allow the IA.
copy of the main,
What's there?
main petition also.
Already.
You serve the main copy, will allow, you will allow the IA, 4 days delay, what's there?
Hmm.
What do you say? Any objection, serious objection?
4 days.
Anyway,
Up to the,
we'll
my
take it
lord.
up next week.
Yeah.
Whatever you want to do it, we'll.
My lord, ask him, direct him to serve the copy of the main
Okay.
petition.
Heard
Already,
Mr.
sir.
M. Bagra,
Yes.
learned counsel for the petitioner. In one, in petitioner, in CRP. And please, Mr. N. Cargo,
Yes.
learned counsel enters appearance on behalf of the respondent, sole respondent, Mr. The learned counsel, the petitioner to furnish the copy of the petition to the to Mr. Nkago, learned counsel for the Nkago, learned counsel. That's
Copy serve, Your
in
Honor.
IA,
Hmm.
in IA,
Both the copies serve, Your Honor.
Ah.
Main case and I already.
no, in that case, the Mr. M. Bagra, Mr. M. Bagra, learned counsel has furnished the copy of a petition to Mr. Nkago in the court. Mr. In the IA also. So and so, same, huh? Applicant. This is an application for application under section so and so, section 5 of limitation X so and so, 1963, for condemnation of delay. The condemnation of 4 days delay in filing the corrected civil revision petition. Mr. Nkago, learned counsel appears for the opposite party, public respondent. Mr. No, since Mr. So and so, enters appearance and accepted notice on behalf of the respondent, no formal notice need be served. Mr. M. Bagra has furnished the copy of the IA to Mr. Nkago in the court today. Mr. Let this matter be listed after a week
Okay.
for further consideration. Next week.
Obliged.
Next week after 2 weeks.
After 1 week, if possible. Only consideration delay.
2
My
weeks
lord,
or 1 week?
my lord, next week for IA.
Ah,
Yes.
Yes, 2 weeks.
2 weeks.
Okay, 2
Make it
weeks.
2 weeks.
Obliged.
Obliged.
15 same. 15 was the same. 16.
May I please, my lord?
Yes.
My lord, this criminal petition for causing of FIR, this petitioner respondent number 2 supposed to file and reply.
Yes, where is?
So last occasion on
Mr.
37.
G. Talo appeared.
Yes, he was appeared.
You inform him. We'll take it up next week. Heard Mr. N.
My
Raman.
lord,
under counsel for
I have
petition.
clear mind. My lord,
After 2 weeks.
interim interim
Yes.
may be granted, my lord.
Heard Mr. N. Ramalan, counsel for the petitioners. Mr.
Trial
Non-
processing may be still, my lord.
Non appears for the respondent. However, despite showing the name of Mr. G. Talo, learned counsel, who is yet to file the power list on behalf of respondent number 2. Who is respondent number 1?
State, my lord.
State.
Yes.
State is not appearing.
SIT, my lord.
SIT
So
council
SIT cannot be represented by anybody.
we can represent it, your lordship,
Yes.
but
You represent.
yes, your lordship.
Uh,
But the standing council
on
is
the
there.
prayer of learned counsel for the parties, list this matter after 2 weeks.
Yes, my lord. My lord,
2
till
weeks.
then, interim protection, interim stay may be
Interim order earlier passed. Interim order is there.
Interim order was not given, my lord, because the honorable court has said that until and unless appearance of the petition number 2,
What is
then
this?
only considered. This FIR is falsely registered here in Itanagar WPS initially, my lord. And thereafter, that case was transferred to SIT, whereas section 498A and then read with section 4 of Dowry Prohibition Act. So the case was manipulated by the father of the.
So what is the stage? It's under investigation.
Yeah, no, my charge sheet already filed and trial already began, and now it speaks for CC, my lord, consideration
You
of
inform
charge.
him, we'll take it up tomorrow or next week. Next week
Next
for
week,
interim consider, next week.
Next.
List this way. You
Much-
inform him.
my lord.
Obliged.
Your Honor,
Yes,
with the criminal appeal under section 374 of the CRPC, there's no representation on behalf of respondent number 2.
Hmm?
There has been no representation on behalf of respondent number 2,
Yes.
who is the informant.
Amicus was appointed, lordship.
Huh?
Amicus was appointed, lordship. In the court, the court says his name is reflected.
Yes.
So paper book may be served upon him also, lordship.
You have received the paper books.
Lordship, I have
It has
received.
been admitted.
Lordship.
Hmm? Has it been admitted? Sir?
Yes.
Yes. Office note dated 11/09/2024 reflects that paper books have been served to all the parties. List since the matter has already been admitted, list this matter for hearing. After judicial course, after
Judicial course.
4 weeks.
4 weeks.
4 weeks.
Like,
Much obliged, Your Honor.
Yes,
Yes, my lord, service has already been completed.
completed.
Yes.
Service, your lordship, I have seen the record is not awaited. No, service, your lordship. Complete power. Service is perhaps awaited, your lordship.
Respondent number 2,
Awaited.
what about others?
Only respond number 2, you say, appeal against conviction, your lordship.
Okay,
Yes. On 2/9/24, it has already been received.
Okay. Steps, when did you take the steps? One month.
Yes.
19 did do it, not even a month. We'll wait for some time.
Yes, on,
In that
on,
case-
it is reflected on to 9/24. It was
No.
We have to go through the
yes.
record of the court, your lordship.
Yes.
But record of the court says the service is awaited.
Yeah, the notice was issued on 19/8 only. Records have been received.
Yes, record received,
Record has been received. What is to be done in that case?
direct to prepare the paper book, and in the meantime, the service upon response number 2 may be
We'll
awaited.
wait for some time. And we'll direct, in the meantime, we'll direct it for preparation of the paper book, right?
Otherwise, my lord, since the conviction is highest conviction under 367 is 3 years, 1 month only.
Hmm.
The earlier council would have filed an application under 389.
It's okay, we'll
suppose
wait for some time since you have taken already stage, he's a party here, all right? Heard Mr. G. Lolan, learned counsel for the appellant. Office note dated 16/09/2024 reflects that trial court records have been received. And the service upon respondent number 2 is still awaiting. In view of, let this matter be, list of, in view of the above, let this matter be listed after 3 weeks. Awaiting service report in respect of respondent number 2. In the meantime, raise it to prepare paper book. We'll take it after 3 weeks only.
Your lordship, cost to be borne by the petitioner appellant, your lordship.
Otherwise, maybe fix 2 weeks. 2 weeks, it will be better.
What will happen? Nothing will happen. Then make it 2 weeks, further 2 weeks. Paper book,
Paper book, your lordship, it may take time, your lordship. It's a registry may be directed and
take it up. We have directed
yes, your lordship.
registry to prepare paper book.
Obliged. Same, your lordship.
Same,
Same, your
Yes.
lordship.
same order. Let me see. Yes, same order.
Same one. Obliged.
My lord, kindly pass over the matter for the time being.
So you'll have to miss that. Why?
This has to be taken up, my lord, today.
My lord,
Yesterday
connecting
also I
counsel-
was ready, my lord.
Council right now is engaged in another call. He will be here soon. Yes, yes. Obliged.
Mr. Tapi is the appellant here.
Huh?
Mr. Tapi is the appellant here.
Yes.
I'm for respondent.
Do you agree that it should be remanded back?
I agree, madam, because finding of the first appellate court did not reveal anything about the insufficiency of the evidence.
Hmm. what is to be done? Will not enter into the merit. On the consent of the party, let the matter be remanded back for retrial.
The board of first appellate court.
What do you say? You just tell us, otherwise we'll have to hear on merit. Is that it?
Yes.
Where is that,
For remanding back, I think my lord, if consent, can it be remanded back? Consent of the parties.
it's an instituted appeal.
Yes, my lord. Otherwise on merit, the,
No, this has been fixed for today.
yes, sir.
You were not there yesterday.
Yes, now,
Then Mr. Tapin has said, what is the order of the first appellate court?
first appellate court says,
The impugned judgment of the trial court is set aside. The trial court is at liberty to receive additional evidence and frame additional issues for proper adjudication. All the factual and legal issues irrespective of any observation made in this appeal. Send back the LCR along with. Yes, this is the order.
yes,
How you are aggrieved? You are not aggrieved.
I'm not,
Is it in your favor?
yes, this is in my power. Otherwise, I'm not agree.
Where is?
27.
My lordship, this matter may be taken up after on 2 o'clock.
Why?
Mr. Estapin, he is on legs on court number 1.
All matters are at 2 o'clock. What to do? Okay, we'll see.
We have received the paper book, Lordship.
Yes,
We have received the paper book,
so,
but the appellant party is absent.
Appellant
party is absent, Lordship.
legal aid counsel, who is that?
Ovinkar,
What is the sentence?
Lordship, conviction 10 years, Lordship, with a fine of 1 lakh. Offense 20B and DPS Act,
NDPS.
Lordship.
Why this, with that? Oh, Bingap.
Lordship.
Who is your Bingap?
She is absent today.
Sri or MS?
MS, Lordship. OM Bingap.
The number of cases she has been appointed and I've come across, she hardly appears. Do you have any idea?
No, Lordship.
Should we pass an order
Lordship, let it be, Lordship, on the next.
indicating his her conduct? Learned legal, Mr. Learned legal aid counsel, O Bingap, MS, O Bingap is not present today. He is not present, Mr. El Hage, MS El Hage, learned additional PP is present. You inform her, will not pass any advice orders
Lordship.
today. In view of the above, let this matter be listed after 2 weeks.
Lordship.
After 2 weeks. The MS Hage, then additional PP is requested to inform the legal aid counsel, MS Obinger, that on the next date, the matter shall be taken up for final disposal.
Like,
My lord, this item will be taken up as our last item.
Why?
My lord, conducting motion in another court.
What is the matter?
Lordship, this is a matter returning to check bounce case pending before Lanet JMFC.
Yes.
They have said, Lordship, in last occasion, they have said there is no cause of action against them. In that matter, Lordship, the Honorable Court has asked us to file an affidavit showing that the payment has been made to them. And Lordship, with that, we have filed an affidavit stating that some amount has been paid to them. So the cause of action error. So please, if that Lord, this matter can be taken after a week, Lordship. There's no, since there's an interim in favor of them also.
Yeah. So this 138.
Yes, Lord, once a criminal trial pending before Lanet's JMFC.
138.
Yes, Lordship.
138 proceedings.
Yes, Lordship. And the Honorable
So
Court
what
has,
is your, what do you stand?
Lordship, there is a cause of action. Even if there's no cause of action, the Lordship, that a trial court has to appreciate that. After taking evidence, then we'll get to know that whether there is a legally debt liabilities or not. Since Lordship, we have executed an agreement on 2023.
Conditional agreement.
Yes, conditional.
No, you have made an agreement.
Yes, Lordship.
In the happening of certain contingencies, you will encash the check.
Yes, Lordship.
Then
Lordship, they had got the payment from the government of
what is
Arunachal.
the law of check says? Once you deliver,
Yes, Lord.
whether it cannot, there cannot be any condition.
Lordship, there can be a condition. There has to be.
We have heard that the post-dated check, pre-dated check.
Yeah. Even Lordship, a post-dated check will be enforceable.
What was the condition? What is the agreement?
Agreement is Lordship saying that since I had given my farm to the appellant, to the petitioner, saying that for construction some work, and Lordship, they had failed to pay me the GST amount and my interest amount, some agreement.
Yes.
Saying that payment will be made to us if the government of Arunachal Pradesh release them some money. If the first installment money was released to them, Lordship. So on that basis, Lordship, we have we have deposited the check and it got bonds, saying that there is no sufficient amount. And Lordship,
On the
that's
ground is that through that there was an agreement.
yes, agreement. And they have only said that they are not denying that we have the agreement. They are saying the cause of action has not arisen. Only on that point they have come before this honorable court.
No one appears, sorry, on the prayer of MS Swenso, then counsel appearing on behalf of Mr. T. Sunil, then counsel for the petitioner, and prayer not being objected to by Mr. V. Jamal, counsel for the respondent. This matter after a week.
Yes, Lordship.
After
See,
2 weeks.
after one,
Maybe the rest of tomorrow.
After a week.
yes, sir. In this interim in favor of them. Yes, ma'am.
You order pass early itself.
My lord,
In this matter, my lord,
Connecting Council has not arrived yet. So my humble request will be
So I have
kindly,
to wait for him.
kindly can it be taken after lunch? After lunch break.
Where he is?
Right now he's standing on his leg at session court.
Huh? Let him be busy. We'll take you after 4 weeks. We have fixed the matter today.
yes, my lord. And this morning I was supposed to leave for Guwahati for some my children's academic matter, my lord. So I have to postpone that also. In that case, my lord, for the fairness of everything, my lord, the interim order that was passed on 6/6/2024 by this honorable court, that may be continued, my lord. The manner that was
There's
not,
the reason matter has been fixed.
my lord,
Because they have filed it for vacating.
My lord.
You have filed it for continuation.
my lord. And the
You
manner,
agree? We'll hear this matter after 4 weeks. In the meantime, earlier order pass will continue. Okay?
Okay.
Are you sure?
I have to take instruction from my senior counsel.
That will be
My lord.
fair for both the parties. My lord. Since the manner it was discontinued, my lord, it was not in a proper way, my lord.
My lord, kindly, before passing any order, let my senior counsel be present himself before this honorable court. My humble request.
Should this court wait for your senior to come?
Uh,
It's over. Matter is the last order. Last matter. This is the last matter. One. No, practically it's your last matter only. That is fixed at 2. Unlisted is for withdrawal only.
For
Anyway,
fairness-
that's you at 2. Tomorrow they may say that this court doesn't sit after 1. But if nobody is ready, why I should sit here? No? Isn't it?
Okay.
If lawyers are not ready to argue the matter, how can the court can sit alone?
My lord.
Yes. Well done, Mr. Hold on, Mr. It's not new filing, it's for withdrawal. Hold them. Yes, again.
Yes, Lordship. Here, Lordship, the petitioner doesn't want to pursue the matter further. So I may be kindly allowed to withdraw the petition, Lordship.
Okay. Mr. B. Jamulan, counsel for the petitioner. Submits that he has an instruction to withdraw the present petition. Mr. You are appearing.
Yes, your lordship.
Mr. T. at the learned counsel for the respondents is present. Mr. In view of the, what is that? B. Jamulan, counsel for the submits that he has. Please, no, before that. Therefore, he prays that the matter may be, he may be allowed to withdraw the, we may be allowed to withdraw the present petition. Mr. Next para. Then Mr. So and so, huh? Next para. Prayer of the petitioner is accepted. Mr. Accordingly, the civil revision petition stands closed on withdrawal.
Duly obliged.
Obliged.
12 o'clock.
And mention item number 27, my lordship,
Yes.
on behalf of Mr. S. Tapin.
Hmm.
My lordship, this matter may be listed after vacation, my lordship.
Why?
He is on legs, court number 1, my lordship, so it won't be possible.
On the prayer of Mr. Estapil, and on the prayer made on behalf of Mr. Estapil, list this matter after puja vacation. First,
There, please.
FAO.
First, revision, my lord.
Revision.
FAO is a branch, my lord.
FAO, first file, we'll hear that first.
Okay.
Or are you withdrawing that?
No, my lord.
Then? CRP. Yes.
So, my lord, this FAO is directed
Why FAO and CRP? Just tell us.
because, my lord, the FAO, inter alia, my lord, with some jurisdictional issues. There are some other ground also on merit. But then my learned brother in their affidavit maybe not gone through properly. We have raised some other ground also. Because discretionary power, of course.
No,
it is-
no, why first appeal against order and CRP?
Yes, because my
Should be
lord,
either of the one,
no, my lord. That
either of the two.
that injunction order, my lord, that temporary injunction order,
Yes.
that we have firstly challenged by this FAO. Because for that, there is a separate provision to go in a higher up forum, my lord. And thereafter, we have subsequently filed a revision also.
Yes.
Because to my understanding, to our understanding, there was a breach of jurisdictional in terms of pecuniary as well as territorial jurisdiction.
That could be also a ground for the appeal.
No, my lord, appeal, those things cannot be taken into consideration. There is a technical difficulties. And that is the reason subsequently I have to.
See, I'll tell you.
Uh.
As you are well aware, if there is a provision of appeal,
My lord.
what's the question of a revision?
My lord, revision.
You are agreed by certain orders,
My lord.
right? If it is appealable,
My lord.
what's the question of revision?
Revision, my lord, because
The revision will come when there is no, if order doesn't, if it's not appealable.
No, my lord. The provision of appeal under Order 42 Rule R, my lord, specifically, if there is any order, temporary injunction order, there is a provision.
Either it will not be appealable order or it should be appealable order. If it is appealable order, what's the question of revision? That's what
That
I'm
is
saying.
appealable order, my lord.
Then
But then
we'll
in that,
consider that only.
in that appeal, my lord, while considering the appeal, my lord, the aspect of that jurisdictional error, my
See,
lord.
you are also agreed in CRP, you are also agreed by the same order.
No, that is different order. And entire
It's a different order.
different order and entire proceeding
It's
we
a
are
different
questioning.
proceeding.
Different proceeding.
Okay.
Therefore,
Okay.
my lord.
Yes.
Huh.
Where is the impugned order?
FAO, my lord.
We start. Huh? No. Are you studying the FAO or CRP?
Partially, let us start CRP, my lord.
Okay, then.
Because this is the route.
Yes, I'm holding the CRP.
So, my lord, kindly some points may be taken note of, my lord.
Yes.
This CRP is directed against the title suit number 19 of 2023, my lord. Now, my lord, on factual aspect, admittedly, my lord, the suit is valued at rupees 5 lakhs, my lord. The pecuniary valuation that lordship will find at page
Yes. Page.
Page my lord, just a minute. Page my lord 40 of my CRP.
40.
Page 40, my lord.
Hmm.
For the purpose of pecuniary jurisdiction at the top, my lord,
Hmm.
the suit is valued at rupees 5 lakhs only. And the Court Fees Act 1870 is not applicable in the state of Arunachal Pradesh, so therefore it is not paid, my lord. This may be kindly taken note of. This is the admitted fact, my lord. Admittedly, my lord, in our written statement, my lord,
Hmm.
at paragraph number 5, at page 89, my lord, page 89, top paragraph 5, page 89.
Hmm.
We have categorically raised the objection, my lord, saying that the suit is undervalued and therefore the suit is not maintainable in this court and proper court fee has not been paid by the plaintiff. So this is not that we have not raised the objection before the honored court.
Wait, this.
Paragraph 5, my lord.
Hmm.
This is the part of the written statement that we have filed. And despite of, my lord, our objection with regard to the jurisdiction that is related to pecuniary, territorial also, that I'll come later on, my lord. The learned trial court below proceeded further.
Hmm.
And the impugned order, my lord, is at page type copy 108, my lord. So basically, my lord, despite of our objection, the suit, it was proceeded further. That is our case. And if we see the law, my lord, CPC read together with Arunachal Pradesh Civil Code Act 2021, the learned court below ought to have returned the plaint to the plaintiff, informing that since the suit is valued at rupees 5 lakhs, this is triable by the junior division, and even the disputed whatsoever the subject matter is, that is of Karadari district, and you file it before the civil judge junior division Karadari, which is available there at zero itself, my lord.
Impugner is page 108.
108, my lord, type copy. So therefore, my lord, what we have done, we have put to question the entire title suit number 19 of 2023 by way of revision. Yes, because there is a jurisdictional error, my lord.
Yes.
Now, my lord, with these two aspects on factual, kindly come to CPC section 15, my lord. Or may I read, my lord? Just one sentence.
CPC.
Section 15.
Section
15, my lord. Court in which suits to be instituted. Every suit shall be instituted in the court of the lowest grade competent to try it. This is, my lord, every suit, not may, shall be instituted, my lord. Now let us read together with Arunachal Pradesh Civil Code Act 2021, my lord. If my lord is having the 2021. Section 3, my lord, second page, classes of civil court. In addition to the courts established under any other law for the time being in force, there shall be established the following classes of civil courts in the state. A, court of district judge. B, court of an additional district judge. C, court of civil judge senior division. D, court of a civil judge junior division. Then customary court, my lord. This is the hierarchy, my lord. And if my lord come to section,
So you mean to that the lowest, as per section 15, they should have instituted a title suit before the customary court?
no, my lord, before the junior division. Why? Because my lord may kindly come to page, section 14, my lord.
Yes.
It says, my lord, jurisdiction of a court of civil judge junior division, my lord. The jurisdiction of a court of civil judge junior division shall extend to all the original suits and proceedings of a civil nature and subject to the provisions of the Code of Civil Procedure 1908 or any other law for the time being in force. The pecuniary jurisdiction of the Court of Civil Judge Junior Division shall extend to all civil suits which do not exceed rupees 10 lakhs, or as may be prescribed by the government in consultation with the High Court. So if we read together section 15 of CPC with section 14 of AP Civil Code Act 2021, my lord.
It's up to 10 lakhs,
Up to 10 lakhs, my lord.
junior division.
Junior division, my lord.
But how you have valued the suit?
That has to be, valuation is completely, of course, depend upon the plaintiff. Plaintiff's discretion. But then such valuation, Honorable Apex Court, there are so many judgments, should not be arbitrary or on the pace of record. It should not be valued in such a manner to suit the filing of same suit before the particular bench.
Precisely, that's why I'm asking. That's the precisely reason I'm asking.
There is no any.
How the suits are valued?
And this is for a simpliciter, my lord, for a declaration of certain rights and title. Even 5 lakhs.
That is the reason I'm asking.
My lord.
How it is valued?
Suit is valued if suppose there is any suits related to property, my lord, or mason profit.
If it's not properly, then it's a
in
declaration.
In Assam, my lord, for declaration, hardly 100 rupees, 200 rupees, 300 rupees. This is the price.
We're not dealing with Assam. We're dealing
Because
with Arunachal. Yes.
Because, my lord, there they have to pay the court fee also. Here we don't have to pay the court fee. Therefore, 5 lakhs, 10 lakhs for simply the declaration of that right and title also, my lord.
That cannot be.
That cannot be, my lord.
That is something cannot be permitted under the law.
My lord. So now, therefore, my lord, we have raised the objection in our written statement, saying that no, this plan should be returned to the.
Just because they have valued it 5 lakhs.
My lord.
So CGM doesn't have the jurisdiction, pecuniary jurisdiction.
No, the competent right forum is the junior division Falin.
That's what I'm saying.
My lord.
This civil judge junior division, senior division has, it has been filed before the senior division,
my lord.
Yeah.
And senior division, my lord, is the Civil Judge Senior Division 0.
Hmm.
Of course, my lord, having subsequently extended the jurisdiction over the Karadari district also. That my learned friend has brought the notification, that we agree with that. But then, my lord, we have to understand one thing. Senior division, junior division and senior division, my lord,
Hmm.
do not have a concurrent exercisable power, my lord. Because, my lord, as per CPC or this Civil Code Act 2021, the order or decree passed by the junior division can be appealed before the senior division, my lord.
Yes.
And my lord, one thing may be kindly taken note of. The matter is completely of Karadari district. This is related to some student organization election. And when Karadari Civil Judge Junior Division is present there, camp at 0, instead of filing that suit there,
Territorial
original suit, my lord, that extension giving the jurisdiction to senior division, my lord, subsequently, that was to my humble understanding, my lord. If suppose, my lord, come late, there are no any junior division or senior division. If any suits has to come up, even that pecuniary jurisdiction is lesser also, that can be directly filed before the Civil Judge Senior Division 0, my lord. As because Kamle district, there is no junior division posted, my lord. But at least, my lord, when junior division is posted at Karadari, my lord, when the pecuniary jurisdiction which you have put it by yourself is for the jurisdiction of Civil Judge Junior.
Which place? Kamle or
Karadari,
Karadari?
Karadari, my lord.
Then why you are saying Kamle?
No, Kamle just I am giving example, my lord. Because Kamle there is no any senior division or junior division. In that case, my lord, the reason behind extending the jurisdiction to this Civil Judge Senior Division 0 by notification subsequently in the year 2023, my lord, that was the intent, my lord, that since in some of the places, district, there's no.
According to you, Kamle, the Karadari has its for Karadari district there is a junior civil judge junior division.
Junior division, my lord, posted there. It was available there when this suit
And
was
cause
filed.
of action arose the Karadari only.
My lord.
When this suit was filed.
My lord.
Okay.
So therefore, this is not the case that we have not raised the objection, my lord. Basically, they are saying that we should have raised the objection at the first instance, or else revision or appeal is not maintainable. This is their case.
Where is your that other ground? Territorial jurisdiction?
Territorial jurisdiction, my lord. Grounds are mentioned at page 14, my lord.
No. Here. In the written statement.
In the written statement, my lord, page 89, my lord.
Yeah.
Paragraph 5, my lord.
Paragraph 5 I have seen.
My lord.
This is of undervalued.
Undervalue, and therefore the suit is not maintainable before this in this court, my lord, before the court below, my lord. And it ought to have been, the court below ought to have been returned the plaint, my lord.
What you have raised the issue of territorial?
Paragraph 10 only, my lord. Paragraph 5 only, my lord.
No. The suit is undervalued and therefore said suit is not maintainable in this court and proper court fee has not been paid. But that's all.
That's
Where
all.
is the pecuniary jurisdiction?
This
Where
is
you have
the,
raised the pecuniary jurisdiction?
this is the, my lord, pecuniary jurisdiction. When we have said that.
Sorry, territorial jurisdiction.
Territorial jurisdiction, my lord, territorial jurisdiction, my lord, since I was not there in the court, no. Specifically, territorial is not mentioned, my lord. But then when, my lord, if suppose, my lord, I file a petition, my lord, writ petition, challenging the, my lord, recruitment rules, my lord. Immediately, my lord, if suppose that is listed before the, if suppose honorable single judge, my lord. On seeing the petition itself, my lord, because these are the basic things, my lord, that needs to be seen. And when that cannot be maintained, my lord, it ought to have been returned, my lord.
Yes, proceed.
Okay. So, my lord is getting my points, I believe. Other than that, my lord, what happened subsequently? Subsequently, my lord, this same respondent applicant, my lord, they have filed another title suit, my lord. Similar matter, my lord. Similar subject matter. Wherein, my lord, they have enhanced the pecuniary valuation at rupees 10 lakhs 50,000, my lord.
Where?
That I have stated in my affidavit, my lord.
Second suit
Second suit, my lord.
on same cause of action.
No, my lord. There is a separate cause of action, my lord. And other than that, also, my lord, recently, my lord, again, what happened? When this honorable court has stayed the entire proceeding of title suit number 19/2024, this applicant, again, they have filed one IA there that I have certified copy. All those records I have. Wherein, my lord, they wanted to amend the course title by enhancing the pecuniary valuation from rupees 5 lakhs to 20 lakhs. My lord. So considering all this aspect, my lord, why they wanted to choose a particular bench, my lord? This is the subsequent IA that they have and wanted to amend the plaint by enhancing the pecuniary valuation from rupees 5 lakhs to 20 lakhs. That your lordship.
That's why I'm asking what is the process, I mean, how this is value.
There is, my lord, no any specific method, my lord. But then there are judgments of Honorable Apex Court wherein they have said that valuation, of course, it is up to the plaintiff, how much amount they valued the suit.
Hmm.
But then it should not be arbitrary.
It is so
That
bad
will be
to
not.
say that.
So therefore, my lord, this title suit number 19/2023 has some erroneous in related to jurisdictional issues in terms of pecuniary as well as territorial. Why I am on territorial, my lord? Chalo, 2023, the extension of jurisdiction, it is given to the senior judge 0, my lord, senior division 0, my lord, even up to Kamle, Karadadi and Kurungame district, my lord. Kurungame, there is a junior division posting at Koloriang. Palin, there is a junior division posted. Only in Kamle district, neither senior division, neither junior division is posted. And lordship, if kindly see the 2021 Act, Civil Code 2021 Act, my lord. The senior division is the appellate court of junior division, my lord. Therefore, I am saying that though senior division, by the notification of that extension, may have the jurisdiction before the Karadadi district also, but both senior divisions and junior divisions, their exercisable jurisdiction is not concurrent, my lord. Kindly come to section 15, my lord, that AP Act 2021, my lord. Section 15, my lord. This will be at section 15. Next page, section 15, subsection 3, my lord. Subsection 3, my lord.
Passed by Court of Civil Justice.
Appeals from the decrees or order passed by the Court of Civil Justice Junior Division in original suits or proceedings of a civil nature shall, when such appeals are allowed by law, lie to the Court of Civil Justice Senior Division of the district. Therefore, my lord, this revision petition, my lord, bears some legal issue also. If lordship can decide, there could be some precedent. Otherwise, my lord, what I will do tomorrow, I'll directly file a title suit before the district judge, my lord. As because pecuniary jurisdiction, it is only given for the junior division up to 10 lakhs. Senior division,
What do you mean by when such appeals are allowed by law?
if there is a provisions in the CPC that is allowable, ma'am.
You have to find out that.
My lord, section 96 is there, my lord. Section 100 is there, my lord. If suppose like we have come this appeal FAO under section 104, read with order 41 rule, R, my lord, 1 R, my lord.
Yeah, this is against the order dated 26/3/2024
Lordship, my lord, the proceeding, my lord.
by the civil judge, senior
Senior division, my lord.
Yes, that's
Yeah.
all.
That's all, my lord. Therefore, my lord, this entire proceeding has to be, my lord, set aside. And
What is the procedure under the CPC in such situation?
CPC,
Yes, what is that order?
order 7, rule 10, my lord.
Order 7, rule 10.
Rule 10, my lord. subject to the provisions of Rule 10A, the plaintiff shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted, my lord. If we read together with section 15, that has to be before the lowest grade. This exercise, my lord, that ought to have been taken up has been not done by the senior judge, civil judge, senior division 0, my lord. And my lord, if any I have some citation. If
Only one. Why so?
one citation,
Why most relevant one?
most relevant one, my lord.
Give the most relevant one. One is enough.
Okay. 2018 GLT, volume 3.
Two thousand
18, my lord, volume 3, GLT 207, my lord.
volume 3, 2007.
7, my lord.
Yes.
Here in this case, my lord, I am relying on two aspects, my lord. One, that when there is a prescription of pecuniary jurisdiction, my lord, the matter should be returned here for trial or for hearing in appeal, my lord. Another, my lord, what my friend has objected in their IA, my lord, they have said this appeal is not maintainable, my lord, saying that as per Bengal, Agra, Assam Civil Code Act 1887, as per the pecuniary jurisdiction of that appellate forum, this appeal ought to have been filed before the district judge. Wherein, my lord, in affidavit, I have replied that Bengal, Agra, Assam and Civil Code Act 1887 is not applicable in the state of Arunachal Pradesh. After coming into the force of this, our own Civil Code Act 2021, my lord. Paragraph 3 onwards, my lord, all may be gone through. Up to 17. This is with regard to the state of Mizoram, my lord. They have their own Civil Code Act since the year 2005, my lord. Paragraph 16 is the conclusion.
Paragraph
16, my lord. 1987 3 SCC 705, my lord. 1987 3 SCC 705. Ratio, my lord.
87?
3 SCC 705. Paragraph only 4 and 5.
70?
705, my lord. Paragraph 4 and 5. Ratio, my lord, here it is, it was laid that there cannot be arbitrary valuation of suit.
Just read it.
Paragraph 4, it says, my lord, under section 15 of the Code of Civil Procedure Code, every plan should be instituted in the court of the lowest grade competent to try it. And if the value of the suit was rupees 42,000 only, it had to be filed in the City Civil Court of Calcutta and not on the original side of the High Court. The principles which regulate the pecuniary jurisdiction of civil courts are well settled. Ordinarily, the valuation or a suit depends upon the reliefs claimed therein, and the plaintiff's valuation in his plaint determines the court in which it can be presented. It is also true that the plaintiff cannot invoke the jurisdiction of a court by either grossly overvaluing or grossly undervaluing a suit. The court always has the jurisdiction to prevent the abuse of the process of law. Under Rule 10 of Order 7 of the CPC, the plaint can be returned at any stage of the suit for presentation to the court in which the suit should have been instituted. The question for consideration in this case is whether, in the present case, the plaint has been grossly overvalued with the object of bringing it within the jurisdiction of the High Court. When the suit is filed for the recovery of money, the amount claimed has to be included in determining the value of the suit. In the instant case, the appellant has claimed a decree of rupees 78,000 at the rate of rupees 7,800 per month for the period between February 1, 1985 and November 30, 1985, on the footing that the respondent's possession was unauthorized or illegal and he was liable to pay Mesne profits or damages. The question whether the appellant would be entitled to a decree for Mesne profit damage at the rate of rupees 7,800 per month or at any other rate after the termination of the tenancy is a matter which has to be decided in a suit. If ultimately it is found that the appellant is entitled to get Mesne profit or damages for the period subsequent to February 1, 1985, then that C is only entitled to receive rupees 1,400 per month. Subsequent to February 1, 1985, could not have been disposed of at a preliminary stage even before the trial had commenced. That question has to be decided at the conclusion of the trial along with other issues arising in the suit. Having regard to some of the decisions on which reliance is placed by the appellant in the course of appeal, absurd nor imaginary, it needs judicial consideration. The acceptance of the view put forward by the respondent may lead to encouraging a tenant who has forfeited his right to the tenancy to carry on a dilatory litigation without compensating the landlord suitably for the loss suffered by him on account of the unreasonable deprivation of the possession of the premises over a long period until he is able to get possession of the premises through the court. We cannot therefore state at this stage that the claim of the Mesne profit damages had been made without a good faith and with the sole object of instituting the said suit before the High Court of Calcutta, even though it had no jurisdiction to try it. We do not agree with the submission made on behalf of the respondent that the appellant had dishonestly and intensely inflated the value of the suit in order to invite the jurisdiction of a particular court which has no jurisdiction otherwise. if Mesnepopis's damages are found to be payable when the claim made at the rate of rupees 7,800 per month for the premises of nature in question, which is situated in Kolkata, does not appear to be fanciful having regard to the prevailing situation. We, however, express no opinion on the actual amount that may be awarded as Mesnepopis's damages in the event of the liability to pay it being established.
Next. It's
Next, my lord. We are of the view that on the facts and in the circumstances of the case, the High Court was in error in prejudging the issue relating to the right. So, my lord, basically, what it says, my lord, that pecuniary jurisdiction my lord, the valuation, my lord, so that can be always checked by the court to avoid the abuse of the process, my lord. So therefore, that particular aspect, my
No,
lord.
for such a situation, there is no problem. To value there is no problem in valuation. When in such a situation like you, how is this to be valued? The declaration of the
Certain rights, my lord. There is no any method, my lord.
No, not a prescribed method.
My lord.
It should be
of any right without having any monetary or financial or any immovable property involved in the suit. That is a criteria.
okay. Next.
And my lord, this citation next is 2027 SCC 366, my lord.
2027.
2020, my lord.
Okay.
Volume 7, 366, my lord. Paragraph 23, 23.1 and 23.10, my lord.
2020.
No, my lord. Paragraph 23, my lord.
No.
Or 2027 SCC, my lord.
2027 SCC.
My lord. 366 page, my lord. Para 23, my lord. And then 20.1, my lord.
What does it say?
And then 23.10, my lord.
What does
It says, my lord, like, just to differ from what has they have stated in their IA, my lord, that to raise the objection under Order 7, Rule 11, this is their affidavit. They have said that we have not filed the application under Order 7, Rule 11. In this judgment, Honorable Apex Court has said that is not required. What is the requirement is that the trial court should be, my lord, live, active, should see just before, my lord, as I have given one example, if suppose any matters comes up before your lordship, challenging the recruitment rule.
This court is very poor in analyzing the examples. Please, let that be straightforward.
My lord. So, my lord, here in this ratio it says, my lord.
I always look at what is the spade. Spade is a spade.
My lord.
I never try to analyze this is something else. If I find that this is a spade is a spade.
My lord. So here in this, my lord, then may I read para 23, my lord. It says, we have heard the learned counsel for the parties. Pardon, my lord.
It's okay. Don't have
This
to
is on whether
you don't have
application.
to. It is not a requirement under the law to you file an application under Rule 7. The Order 7
rule.
wrong code, you'll have to.
Or if there is no cause of action, then
Following the Order 10.
Order 10 or
10A. 10 is subject to 10A.
10A, my lord.
10A, probably it's a procedure.
Procedure, my lord,
Return-
for
when-
filing
when it has-
application,
If it is to be returned, the subject rule
10A
10A has to be followed.
followed.
That's all. On that thing only.
On that thing, my lord.
That's all.
So mandatorily, it is not required, my lord, that we have to file the application before the learned court below. If we have raised the objection in our written statement, that is suffice, my lord.
I think it's elementary.
My lord,
It's elementary.
my lord.
It's an elementary. All these things are elementary.
My lord. Elementary in the sense, my lord, these are procedural part.
That's what I'm
Course.
saying. It's an elementary
My
of
lord.
the procedure.
Ah,
Is not it?
my lord.
Okay.
And when objection, my lord,
Anything,
has to be
any other judgment?
judgment, my lord.
It's okay, enough, it's enough.
Another judgment is, my lord, suppose plaint is returned, then whether there should be a de novo trial
That we're not concerned now.
or it will be started from the, if suppose some evidences it is on that issue.
Just give the citation.
My lord, 2020 again,
Yes.
volume 12, my lord,
Hmm.
page 667, my lord. This is a reference case, my lord, by
para-
full court, para 14 to 20, my lord.
14 to 20.
14 to 20, my lord.
Hmm.
The ratio is, my lord, in the case of plain return to be presented to proper court, the trial should be fresh, a de novo. That's all, ma'am. Subject to, my lord, if any.
Not complicate the matter, we'll simply consider it, determine it
Before, my lord,
on the
I-
basis of the
Yes.
fact and the law.
Before, my lord, I may reply to the submission letter.
Hmm.
Now, my lord, I have a request for the petitioner, my lord. First, he is to make this clear. This petition is whether under Article 227 or under Article 115 of this. My lord, why I'm saying, because law is saying, my lord, these two cannot go together. If it is 227, then my lord knows the what is the scope of Article 227. And if it is 115, see these are completely two different things. This cannot be together. If that's why my lord, that clarification has to be made first. And accordingly, I will advance my action. Otherwise, my lord, it will jumble up because this petition itself is defective.
So we'll.
No, he has to make
So-
it clear.
so-
Whether this is a petition under Article 227.
In that case,
No, cannot be repeat because the law is very clear. It says that you cannot at a time, you cannot submit two applications, 115 as well as 227. I will not 227 is basically also a revisional jurisdiction of this honorable court, having the superintendence over the lower court matter. Now the question is that now the scope of both this 115 and 227 is completely distinct. That's why I am praying, my lord. He has led him to take the step. Because after hearing my argument, he should not change his saying that what is this petition actually? Because if he says that this is 227,
You have heard him, he said
227.
227, read with
Then my lord, I
150.
said
On
that
that, on that basis you argue?
My lord.
Yes,
Now the issue is, my lord, here.
CRP
27.
under 227, read with.
Not CRP, not Article 227, my lord.
No, CRP in the sense,
115
civil division petition,
is 115.
115 CPC.
Yes.
Yes.
And now Article 227.
What he said,
Yes, sir. So
this petition is,
now-
petition is under 227, Article 227 of the Constitution, read with 115
Yes.
CPC.
So my first submission itself, my lord, this petition cannot go together.
Hmm.
Now I will deal with that issue.
Hmm.
First, my lord, basically my understanding of today, my friend, It's only raising the issues. Earlier, my lord, when the petition was filed, on two grounds, this petition was filed. First is pecuniary jurisdiction, another is territorial jurisdiction. Now, so for pecuniary jurisdiction is saying that, okay, this suit was valued at rupees 5 lakhs. So this should have been presented before the junior division of Karadati. Should not have been presented before the senior judge division. Now, another condition was that senior division 0 doesn't have jurisdiction over Karadati. But after my reply, now he has admitted, no, we are not speaking about the territorial jurisdiction. Why don't we kindly take second note? Now, admitted position, because I have enclosed the notification of our own High Court. Where
IA or did you file any objection in the revision?
for vacation of the
revision petition? Did you file any?
my lord, I filed for vacation of the
No.
order 1118, my lord, my IA.
(118) of is
80 of 2024.
not in civil revision.
In civil revision.
Okay.
Civil revision, it is 114. 118. 118.
Yes.
Yes. Now, may I take your own advice? Because now it is not in dispute, madam. So for,
If it is not dispute, it's okay.
so for territorial,
Territorial jurisdiction is no longer is a dispute.
no longer in dispute.
You are admitting.
No, my lord, I am admitting that. But then still what I have argued, my lord, earlier also. This extension, why it was given, my lord? They do not enjoy the concurrent jurisdiction, my lord. Section 15, subsection 3 says, my lord,
It's okay.
senior division is the, my lord, appellate.
I'll hear you on as a rejoinder. You just,
Madam, may I take my lord, page number 28, madam, for
Hmm.
my IA.
28.
28. Okay. Madam, serial number 2.
Yes.
Chief Judicial Magistrate, Hero comes civil judge, senior division, my lord, has seen.
Page 28.
Page 28 of my IA.
Serial number 2.
Notification dated 7/7/2023.
Yes.
Serial number 2, Chief Judicial Magistrate, Hero comes civil judge, senior division, my lord. Earlier, territorial jurisdiction was Lower Subansiri and Kurukame only, madam. Now, after this notification, my lord, we find at my lord column 1, 2, 3, 4, my lord. Now, this has been extended after 2023, Lower Subansiri, Kurukame, Garadadi, and Kamlena. Now, am I clear, madam? Meaning there, my lord, at the time when the suit was entertained, at the time, the civil judge senior division, he was the civil judge of entire this Lower Subansiri, Kurukame, Garadadi, and Kamlena. 4 districts.
When you institute the suit.
Title suit, madam, at that point. So, madam, the civil judge senior division, it is a competent territorial jurisdiction. There is no dispute. This is admitted position now. Now, so far, madam, cause of action pertains to Karadari. It falls under senior division. Now, the only issue now remains is, my lord, the only issue before my lord is that.
Pecuniary jurisdiction.
Yes. If it happens, pecuniary jurisdiction 5 blocks, whether senior division is competent to entertain, or if has entertained, whether this is illegal or what consequence will follow. This is only the issue, my lord, here it is. Now, for that one, my lord, now the laws say, now I will start with our own act, Arunachal Pradesh Civil Code Act. First. Then, my lord, I will start. Civil Code Act section 13, madam. This is very important. Section 13 is important. Madam has got.
Yes.
Section 13, madam. Jurisdiction of a court of civil judge senior division. The jurisdiction of the Court of Civil Justice Senior Division shall extend to all original suit and proceedings of a civil nature as prescribed in the Code of Civil Procedure. I'll just pause here. Now, literal interpretation and understanding of this act is generally what happened, my lord, that the original court, jurisdiction of the shall extend to all original suit. Generally, there never used to be any, my lord, this pecuniary jurisdiction is matter. This clearly says that he has jurisdiction. It can go above unlimited, and there is no prescription for the lower side. Now let's read 14 now. Section 49. Jurisdiction of the Court of Civil Justice Junior Division. The jurisdiction of the Court of Civil Justice Junior Division shall extend to all original suit and proceeding of the civil nature, and subject to the provision of the Code of Civil Procedure 1908 or any other law for the time being in force, the pecuniary jurisdiction of the Court of Civil Justice shall extend to all civil suits which do not exceed rupees 10 lakhs or as may be prescribed by the government. So for section 14 is my lord, that upper limit jurisdiction has been prescribed for my lord junior division my lord, civil judge my lord. Now the my lord, law says my lord that higher court my lord, the court of the higher forum my lord can take up the matter of my lord lesser value my lord. The law says that the lower court cannot take up the matter of the higher value of the higher jurisdiction. Now, meaning there, I will support with my judgment why this arrangement is being made. There is a judgment which supports my argument. Basically, it's this way, so for junior division, he cannot take up more than 10. But there is no bar. So for civil judge is considered senior division. If he wants to take up the matter of even of below 10 lakhs, process there is no illegality, no illegality. Why this is saying, I have a judgment to support. This says that this arrangement is to facilitate and to make the civil judge less burden. So that if so many matters is only taken up by the one civil judge, you won't be able to perform all the things. So this is left to that suspicion that even if you take up the matter of lesser jurisdiction, this is not wrong and says that there is no wrong because higher forum can always take up the matter of the wrong. Now, my case, what I am arguing is my there is because my lord has in section 13, there is no bar. No pecuniary jurisdiction so far. Civil judge senior division is there, my lord. It's not mentioned, my lord. My lord has seen, my lord. It's not saying that you cannot take up the value of this much of amount. It's only saying that junior division. Now the question before is that. Now suppose the civil judge senior division, my understanding, my lord, it says law says can take up the matter of the subordinate court, subordinate civil judge matter. And in that situation, proceeding will not be initiated.
When there is a civil judge junior division, why should take up the matter?
No, that's why matter. Now question is that that's why matter.
Having the different, he may not have the upper limitation, pecuniary jurisdiction. But then for the civil judge junior division, it is fixed, it should not exceed 10 lakhs.
My lord.
So if the value is of 10 lakhs, within the 10 lakhs, why he should take up just because that it may burden with the civil judge junior division? Can it be permitted?
But this is what I understand.
No, that is in certain cases, there may not be, as such illegality to take up by the higher forum. But if there is the court having the jurisdiction, then why?
No,
Why? This is
I've done some research, my lord. All the law is saying, my lord, even though may be there, No wrong.
We'll have to treat with the facts.
My lord will be also laying some law. This will be for future even for us also. Now, my lord, another issue. My lord. Now another issue, my lord, is like, suppose, assuming, for a while, I will come to those citations. Assuming, my lord, that now, my lord, present status is, my lord.
You are right. You have 13, 14. We have to read together.
Yes.
Along with that 13 and 14, and then you have to read that 15, 15.3, 15.3 also. 15.3.
This appeal part.
Yes.
We will come to that part, my lord. My lord, definitely, my lord will finalize that. My lord. But so far, my understanding, my lord, I will try to convince my lord that.
So, according to you, there is no bar or there cannot be any illegality, even if the higher court takes up the matter which is
of the
lower
so far,
security jurisdiction.
Okay. I will support with Jasmine.
Okay.
That is the law point, my lord.
Yes.
So far in this issue. Now another point. I will another ground. Now let's assume, my lord, that civil just unit did not have the assuming did not have a territorial jurisdiction. Let's assume for the sake of. Now the law says this is the case admitted position. Case went to till framing of the issue. Case was pending. They participated entire in the proceeding. That's why order 39 was passed. Now the section 21.7 2 of the CPC say appellate court and the revisional court, if this territorial jurisdiction or pecuniary jurisdiction is not raised at the initial stage, if it is not at the initial stage, you cannot raise for the first time before the appellate court or the revisional court. This point is very important. Now the question is that whether he can raise this issue at this stage without admitting the fact whether it has a jurisdiction or not.
See, they have in written statement, they have given the clear, verified. Now, no issues is yet to be framed. What?
Now I will.
At what stage the parties are allowed to raise the point?
Now I will.
First stage would be the written statement.
That's
And then if issues are raised, points are raised, then the issue has to be framed. It's not it. Then only deliberation will be on.
Yes.
Now the issues has not been framed. Only written statement has been filed. So you cannot say that at this stage.
That's why in
That-
the written statement, Madhu.
Yes.
Let's see. Let's see their statement. I will come one by one.
But you tell us,
Yes, I'm coming.
apart from this.
This is from Madhu. Suit is undervalued.
Yes.
And therefore the sale is not maintainable in this court. Suit is not maintainable. Territorial jurisdiction, they have no raise. Now pecuniary. Now, law is saying, what happens in generally in the law policy? There is when you file the written statement, you file the times. Then there is a provision under Order 7 rule. Order 7 rule. Rule 11. Generally, what we do, because there is a remedy.
You read the paragraph 7, paragraph 5 again
Paragraph 5. Yes.
of the written statement.
Yes. This suit is undervalued.
Yes.
Undervalued. Now it's saying that I have undervalued. I will come to that part also. And therefore, the sale is not maintainable. Now now my lord will see.
He, according to you, he did not say that. He did not say in the written statement. He has not stated that since the suit is valued at 5 lakhs, right? This is the civil judge junior division, for that matter, the court which has been in which the suit has been filed has no jurisdiction, pecuniary jurisdiction. What he has said is the suit is undervalued.
I have understood this. That's why I'm saying I will show the provision when there is suit is undervalued. what is the process? I will.
No, you have not understood me. I am arguing in your favor.
My lord.
He has just suit his other value.
Understood.
Therefore, it is not maintainable.
Maintainable.
He did not say that since suit has been valued at 5 lakhs.
That's why you are don't have a pecuniary.
Yes,
situation.
that he has
no,
not
no,
said.
my lord. That's why my lord, I am on that point. my lord. Because undervaluation is a different.
Why I am saying that's why you come to that only.
That's why my lord.
That would
Now-
be your
now,
that would be
another issue.
yeah, that's why I ask you to read again and again. You come to that directly. That's not
My lord. Number
beat
one,
around the bush.
my first point, my lord, not raised at all.
Yeah.
Now it is not permissible under. Now let's, for the sake of assuming argument, my lord, in
Yes.
this paragraph, he is written, there is no pecuniary justice. I am assuming for a while. my lord. Then what is the remedy in that situation also? Generally, what happens in the calculation is something like that. You write the written statement, you write the claim, then if claim is not maintainable, the provision is Order 7 Rule 11 CPC. It says that you can always raise under application under Order 7, saying that why this suit is not met. He has not exhausted that provision.
Okay, before that, when this notification was issued, confirming with jurisdiction to CGM, oh sorry, Chief Judicial, no, this Civil Justice Senior Division. Was there any junior division at Karadadi?
At that time was there, but now it's not there.
Suppose today,
Yes.
forget about this case.
Now,
For a-
even in
for a-
my
for-
Senate
for-
back, there is no one.
No, forget about this case.
Yes,
Suppose if clients come to you
yes.
to file a suit, which is valued at 5 lakhs, where you'll go?
Now, my lord, there is no.
You'll file the suit before the junior division because it's in zero. Karadari is too far. What you will advise?
No, my lord. Suppose now, my lord has put a very interesting issue. Now, so far, my lord, suppose today, suppose somebody comes. Now we have to assume that there is 2 junior judges also there.
Senior judge is there.
Now,
Senior judge is at zero. It's better place, beautiful,
Karadari is
beautiful
also
place.
functioning in the same building.
Yes.
Junior, he was not sitting at Karadari in the same building. Both are functioning in the same.
But now having the jurisdiction over the area,
Yes,
if there is a junior division,
junior division.
then
But this civil judge has a jurisdiction over on the matter.
yes.
Now, my answer would be like,
Well, not take it that whatever you give the answer to the query, I mean the hypothetical thing, will not apply it in this case. Just give the honest answer.
honest.
Yes.
Honest answer, definitely I will go to the junior division.
Okay. That's all.
I will go to.
That's it.
But the problem is here.
Come to your case.
Now, madam, the problem is here. Suppose file inadvertently it is filed.
Yes.
Or knowingly also filed. Suppose, then again I say that now it is the priority of the civil judge senior division to say, I will not take up the matter.
So in that case, I'll just give you another question. Suppose inadvertently it has been filed.
Yes.
Now you have to cure it now. If it comes to you again, if some of your colleague has filed it inadvertently, or maybe whatever reason. So if it comes to get it, I mean, undo or redo it, what do you suggest?
That's no, but earlier when I filed, I have filed even one amendment petition.
Yes.
Now after that I have done research because
Yes.
I was also not having knowledge about.
Yes.
After this case only I have to come to a certain point
Yes.
about the law. But to be very candid,
Yes.
now my understanding.
No,
of law-
we're learning every day.
Yes, yes. Now after this only case, because I was also having the impression before this case that civil judge once because when I was handling this matter, I was also the impression. That's why I filed the amendment petition. Now after research, I find it's not required. Why? The law is saying all the time, it is up to the higher civil judge, senior division, if he exercise the power and says that I will do that thing. There is no limit. This is what the law is saying, and saying that this arrangement is just for the benefit of the civil judge. Now, he can decline. He may say, no, this is the thing, you go there. But if he exercise the jurisdiction, my lord, there is no any issue. This is my understanding of the law after this case. Earlier was my impression, no. once pecuniary is written, you have to go there only. No. Now is a evident position. Now is very, I don't, even this matter will, tomorrow, madam, even this will become something like academic situation only. And why now, madam? There is no Karadani unit division now at that. Now only civil just is senior.
It is there.
There. Now it's not there. Where?
In your notification itself, down below, kindly read the down below.
I am saying posted, not transferred. You have written.
In charge is the senior division 0 itself, my lord. Down below that notification.
Where it is.
Okay, let it be there. Now it's like senior division has been made, the same judge.
Is junior division.
Now, my lord, earlier junior division has been transferred. Now I think civil judge senior division, I think he is in charge. Now he is saying the same person is senior division as well as junior division. Am I right? Okay. Yes.
No, in certain situation, in a state like Arunachal, if there is no officer, judicial officer, they cannot conferring a power. It's not a. I mean, it's not. It's
May I continue
perfectly
my-
all right.
May I continue my another point?
Yes.
Now, my lord, first point is that the civil justice is competent. Second, my lord, issue of jurisdiction was not raised. Not raised, my lord has read out the only said swift valuation. This is a very different thing, not, and now I said, my lord, even if he has written pecuniary jurisdiction, but remedy is there, alternative remedy. Statutory remedy is CPC there, otherwise what will happen? This we will be sending a wrong signal to all the thing. What will happen tomorrow, my lord? Without exhausting the CPC, my lord, we cannot say that every one of you flock to the High Court invoking Article 227 without exhausting the alternative remedy. And my lord knows the scope and limit of 227 is very limited. I will show when there is a statutory limited, my lord will not interfere under 227. That is very clear. That is taking of decisions, sir. Now my second.
So according to you, the appeal should have been filed before the district judge. Are you saying so?
No, this is not appeal, my lord. We are dealing with the revision.
That's what I'm saying.
But now we are, no, I am not saying that. I am saying, my lord, because he is saying that 227. That's why I am saying. 227 is about superintendent. Its scope is very. Now the law is very established. 227 is not something at the fall of the head. 227 will not be invoked. Even the law is something like that. Okay, even against the interlocutory order, even 227 can be invoked. But your honor, grounds are very limited.
There's another the judgment of the Supreme Court.
I will give one by one, madam. And now the
It
same
said
that
jurisdiction of under 226 cannot be
27.
227
When there is a statutory remedy.
cannot be exercised like a bull in China.
Yes,
China
yes,
shop.
my lord. In the rare of the rare occasion, our judgment of our own High Court judgment and Supreme Court judgment also. Now, what my contention is that you have a remedy. First, you have not mentioned at all in your reports. After that, what we do, what is to be done is like, if you think that the court doesn't have the pecuniary jurisdiction, you should have moved a appropriate application, saying that specifically, categorically, this court doesn't have a pecuniary jurisdiction. They are not done. Then after there has been some adjudication. Now, my lord, let's see at the impugned order. What is this impugned order? Is it that some issue of jurisdiction has been decided, my lord? How this can be an impugned order? I don't understand, my lord. How this can be an impugned order? Where is the issue of jurisdiction has not been decided by the law court as of today, my lord? Am I right, my lord? Let's read the impugned order.
Yes.
What the impugned order is? The plaintiff is represented defendant, and non-appear on the cases fixed for settlement of issue and submission of the list of document. And accordingly, plaintiff filed draft issue by sales, however, he paid for time. None of the defendant have filed draft and documents. The case in the best is also settlement of. Question is number one. Did he ever raise the issue of impunity, territory, jurisdiction before the landed trial? Whether there was any occasion for the landed trial court to adjudicate on the issue whether the court has a pecuniary jurisdiction or not. unless that order is not put. How the my lord will see whether the order is suffers from any perversity, illegality, whether the intervention under 227 can be done. What is the wrong in this interim order? Where is the matter of adjudication? This is a interlocutory order fixing a date for the settlement. So this order goes to show the applicants, they were participating in the trial. And once you have been participating in the trial, you cannot raise that on that issue. What is the perversity in this order? How this can be into order? Because, my lord, first that determination has to be done by the law court, the trial court, that whether I have a jurisdiction or not. There is a remedy for that one. Now I will come to that one. Now, my lord, we will see. May I read, my lord, section 21, 1 and 2 of the CPC. This is very important.
Twenty-one, 22.
21, my lord, section 21, subclause 1 and 2. Madam, this is very important. Some word has to be read properly, madam. I'll just read out. May I read, madam? Objection to jurisdiction. No objection as to the place of suing, madam, shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance, madam, at the earliest possible opportunity. And in all cases where issues are settled at or before such settlement. And madam, now thereafter, madam, the and. This is not only sufficient, the word is and, unless there has been a consequent review of justice. Now I will, madam, why I am saying referring to, this is not the word or, and. This is continuous, madam, conjunctive. Madam saying that it is not only enough. Even, madam, for example, madam, law is saying, madam, in some territorial, wrong territorial jurisdiction, suppose I was supposed to file a suit before the Italian. Wrongly, I filed at SEPA. If I am understanding by this action, madam, this thing. Now it's saying that this thing, you have to raise this issue immediately before at the earliest possible. And thereafter, unless there has been a consequent failure of justice, no objection. Only because you saying that that place doesn't have jurisdiction is not sufficient. Now you have to show in your pleading file what is there that consequent failure of justice has occasioned because of this one. Because it is not sufficient only say that this court doesn't have the territorial or pecuniary jurisdiction. Now, second two, I will show some citation.
Same.
Then, madam.
One is if there cause of place of suing, and other one is pecuniary limits.
Madam.
Same word.
Madam, same madam has what my point. You cannot raise for the first time here. Because there is a remedy you have to raise. Madam, what is
Unless there is a consequential failure of justice.
Yes. Otherwise, madam, even suppose if you raise there, but even then, madam, consequential failure of justice has to be stopped. It is not something only saying doesn't have automatically you won't get the relevant.
Rajesh, that will be a too dangerous proposition.
This is what the judgments all are, what you do, madam.
We'll read it in this context, will determine.
CPC, madam.
But on the face of it, if you accept that, it will be a dangerous proposition.
Yes, madam. And my lord, now my lord will see this order 7, rule 111.
Yes.
Order 7. This is very important.
We'll finish it today or we'll
Madam,
keep it.
I won't take much time. After this, almost I will wind it up, my lord, and I will give you judgment. I won't read the judgment even, my lord. Just highlight the
Section?
My lord,
Order.
my lord, order 7.
Order 7?
Rule 11,
Yes.
B and D, kindly, my lord,
B and
B and, subclause B and D,
capital
my lord, small, my lord.
B and D.
Why I am saying this, he has not exhausted the alternative, because my lord, this learned court has no occasion, there was no occasion to determine this issue. My lord. Now this order 7, my lord,
Yes.
here is a remedy. Now he says, my lord, first I will read. The claim shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claim, my lord, this is very important, where the relief claim is undervalued and the plaintiff, on being required by the court to correct the valuation within the time to be fixed by the court, fails to do so. My lord, this is very important for my case. Why? Suppose, my lord, let's say, my lord, this was undervalued as contended by the petitioner. Now, what the law is saying, you cannot dismiss my lord. Court cannot dismiss my lord. Now, court has to say to the plaintiff, hello, you have to, your claim is undervalued. Now you correct it. My lord, is getting my point.
Yeah. Yes.
It is not something as my learned friend is saying that immediately you have to dismiss. No. Now, what is saying? You correct it. If you don't correct it, thereafter it can be rejected. Now, he is saying that it has been, we have raised the undervalue, but no application under order 11, rule 7 was filed. Now, may I take my lord, order 7, rule 5. Now, my lord, D, my lord. Subclause D. 11, order 7, 11, D, my lord. Now, basically, what we do is, my lord, when any suit is filed wrongly, when the suit is not met, immediately we used to file application under order 7, rule 11, they say this suit is liable to be dismissed. This is the remedy provided in this matter. Now, my lord, one question before this, my lord, is it permissible, my lord, you will just circumvent this procedure, you will straightly come to the High Court, my lord. You are behind it, my lord, know that CPC is a comprehensive court for all the procedures in the flat court. Now, can you, my lord, just then, what is the use of this section? You have to exhaust the alternative right. For this argument, my lord, I am placing. But no application, nothing, never raise the issue of pecuniary jurisdiction, territorial jurisdiction at that point of time, my lord. Straightly coming to the court saying no pecuniary. Now the court is saying if it is undervalued, what is the issue? Court will ask me, you make it a correction, I will correct it and matter will be taken it up, my lord. It's as it is, my lord. It is not something, it entails dismissal. Why he is saying that entire title should be dismissed, my lord? How it can be dismissed, my lord? If the court says this has been undervalued, give me the direction to make. Now, this is what I will say about. Now, my lord. Now, another variance. Another point. Now, my learned friend is saying that dismissing. My lord, law is saying order 7, order A 7 rule 10. Order 7 rule 10. Order 7 rule 10 is, my lord,
not rule 10. Order 7, rule 10.
yes, question of dismissal doesn't. What my friend is.
Return of claim. I have not said dismissal.
This argument, my lord, these are the additional argument, my lord. Their jurisdiction part will always be there. Has a jurisdiction, I will satisfy with the judgment. The return of claim. Now, this is the alternative argument, even if my lord comes tomorrow.
It's in the under the normal circumstances or under the peculiar circumstances that you are claiming that the senior division has the jurisdiction. According to you.
It's in normal circumstances. I will bring on record. Then, my lord, this says, my lord, otherwise, suppose this jurisdiction is for the law. Now, this return of claim is what? Suppose I have filed a suit of suppose 11 lakhs before the civil judge junior division. Now there is a provision, civil judge junior division, senior division cannot straightly dismiss the claim. They are saying that you return it and ask him to file before the proper. Now my friend is all saying that it's completely has to be dismissed. CPC doesn't say that dismissal. There is so many procedures are there. This is just for the sake of additional argument. Now my case so far.
If land has to be returned or undervalued as per Rule 11, Order 7, if it is to be corrected, chance will begin. If it is not, then it will be rejected.
Yes. Then it has to be returned, not rejected.
Rejected.
Now, my lord, I will come, my lord, so far. Now, my lord, I am dealing with his argument on his this petition as a 227. That's why, my lord, later on I will deal again this one more time. Now, my lord, please. Now come to the law point, my lord. Yes.
Don't give too many judgments.
My
Most relevant, the point which you have raised, 2-3 points, just give on that.
This is of the my lord, Bombay High Court. My lord. This is very much, my lord, almost similar situation. What happened, my lord, suit was filed before the civil judge senior division, saying that, and the same issue, my lord, junior division, subject junior division of the junior division, my lord. Then the matter went to the High Court, and High Court, my lord, has given this one, my lord. My lord, let's start from 5. Understanding that what will happen in this situation. Same issue. My friend has not laid down any issue on the same that I'm putting there are 5. In order to answer this question, it would be useful to examine the scheme of Part 4 of the Act deals with civil justice. Unless Section 21, the state government has to determine the number of civil courts subordinate to district court in each district. And Section 22 empowers state government to appoint judges of such court. They are called civil judges. Section 22 further empowers the state government to fix and from time to time alter the local limits of the ordinary jurisdiction of the civil judge. Under Section 23, the state government has also to appoint the places at which the civil judges have to hold their courts within the limits of their respective jurisdiction. Section 24 divides civil judges into 2 classes. Well, these are the referring of CPC matter, this section. Civil judge into 2 classes. Civil judge senior division and civil judge junior division, and provides that the jurisdiction of the civil judge senior division shall extend to all original suit and proceedings of the civil nature, and that of a civil judge junior division to all such suits and proceedings where the subject matter does not exist 25,000 in amount or value. It may be mentioned here that prior to the amendment of this section by Maharashtra Act so and so, which came into force, this limit stood at this 10,000, and by the said amendment, it has been raised to 25,000. Since in this revision application, we are concerned with the section as it stood before its amendment for the purpose of this judgment, I shall refer to this limit at 10,000. Lastly, Section 25 provides that the civil judge senior division, in addition to his ordinary jurisdiction, shall exercise a special jurisdiction in respect of such suit and proceeding as may arise within local districts of the court in the district presided over by the civil judge, so and so. Number parasite. The scheme, this scheme is referring about CPC. The scheme, therefore, which emerged on reading this section together is that A district is divided into suitable areas, and for each such area, a civil court is established over which a civil judge presides. The jurisdiction which such civil judge exercise in such area is termed as ordinary jurisdiction. This is the limit of this territorial jurisdiction. This pecuniary jurisdiction depends upon which of the two classes. it
So
belongs
before
to.
that, just read. Lastly, section 25 provides that the civil judge senior division,
Madam,
in addition to his ordinary jurisdiction, shall exercise a special jurisdiction
madam,
in respect of such suits and proceedings as may arise within the local jurisdiction of the courts in district presided over by the civil judges junior division.
madam.
There's a special jurisdiction has been conferred
That is there. Madam. Now let's come back. Same issue. Now-
apart
now,
from
madam.
ordinary jurisdiction.
Yeah, madam. There are.
Yes.
Now, the jurisdiction which such civil judge exercise in such area is termed as ordinary jurisdiction. This is the limit of his territorial jurisdiction. This pecuniary jurisdiction depends upon which of these two classes he belongs to. If he is a civil judge senior division, he can, my lord, now this is very important. Kindly mark, my lord. If he is civil judge senior division, he can entertain and try all original suit and proceeding irrespective of their valuation. However, if he is a civil judge senior division, this pecuniary jurisdiction is restricted to limit of rupees 10,000 subject to the provision to section 24, with which we are not considering. Thus, a civil judge senior division can entertain and try all suits and proceedings arising within the local limits of his court, irrespective of their valuation. Valuation is not required. While a civil judge junior division can do so only with respect to matters falling within the limits of its junior jurisdiction.
No.
This, however, would still leave suits and proceedings which originate within the territorial limits of a court decided over by civil judge senior division and exceed his pecuniary. So such civil judge would have territorial jurisdiction. He will lay pecuniary jurisdiction in respect of such matters. In other words, such matters would be reach out of the ordinary jurisdiction of the civil judge senior division or civil judge senior division because the former lacks pecuniary jurisdiction, while the latter lacks territorial jurisdiction. In order to meet this situation, the civil judge senior division in the district is invested with special.
Yes,
No, madam.
that is what I'm saying.
Madam.
A
Let's come to-
special jurisdiction.
Madam, let's read, madam, completely.
Hmm.
In order to meet this situation, the civil judge senior division in the district is equipped with special jurisdiction to trial. It is in this way that the act distinguishes between the ordinary jurisdiction and special jurisdiction of the civil judge senior division. Malab, this is dealing with the same CPC, which is applicable to us. This special jurisdiction is saying about the CPC only. To summarize, the ordinary jurisdiction of the civil senior division extends to all those suits and proceedings irrespective of their valuation, which arise within the local limits of the court. While his special jurisdiction extends to only those suits and proceedings which arise beyond the local limits of his court and in the local limits of the court decided court. Now I have para 7. This is very important. What is the junior division? Why it is required? Para 7, last paragraph. 19. From what has been said above, it will appear that every civil court in the district is decided over by the civil judge. It may not always be possible for him to cope up with work on this file. In order to provide for this contingency, Section 23 authorizes the High Court to appoint one or more civil judge to such court to assist the deciding judge in the disposal of the business on his file. Such judges are designated as joint civil judges. Now, under the terms of Section 23, a joint civil judge is appointed to assist in the court of another civil judge as to dispose of such civil business within the limits of his pecuniary jurisdiction as may, subject to the control of the district judge, be referred to him by the judge of such court. Thus, at a given place, there is only one court of civil judge and other judges are attached to that court to assist him. These other judges do not by themselves constitute independent or separate court, but are part of the same court. So and so, if a joint civil judge appointed to the court of civil judge senior division happens to be a civil judge junior division, he only assists the civil judge senior division in disposing of such matter on the file of the court, which fall within his pecuniary jurisdiction. And such appointment does not deprive the latter to entertain and try such matter. It is in this grammar the point involved in assistance. Now, what is this saying? That Para 9.
Hmm.
Para 9. The view of the learned trial was that when civil judge senior division entertains a suit valuation up to 10,000, he must be treated as accepting the same on behalf of joint junior division is not correct. As seen above, a joint civil judge has no independent existence apart from the court to which he is appointed. Hence, even if a joint civil judge junior division were to be appointed, he would not constitute a separate court exercising his ordinary jurisdiction in respect of matter falling within the limits of its pecuniary jurisdiction. As in such case, absence of such appointment, it cannot be said that the civil judge may assess such matter on behalf of so and so and so.
Yeah, the facts are different.
My lord, I will come there. Now, my lord, now the issue here is, my lord, now is saying, my lord, that there is no any wrong matter. Even if senior division take up the matter. This judgment is saying.
This was something in a situation where the senior judge was given a special jurisdiction, and the junior civil judge junior division was appointed to assist him, and was not having a particular no whatever under the scheme only. This was in a particular case at Yatmal. It was done.
My understanding. This whole discussion is in respect of CPC. Same CPC which is governing us.
See,
It's
CPC we can, but there's an amendment in every state. Like we'll have to read with the Civil Courts Act. So far as the pecuniary and territorial is concerned, with along with the notification which you have relied, that has to be seen. That's what I'm saying. It's not all in normal circumstances. CPC, it has to be the Civil Courts Act of the state, the notification, and the CPC has to be read together. There should not be any inconsistency or a contrary provision. So in certain cases, that's why I ask that whether in normal circumstances or a peculiar circumstances, suppose at that point of time, if there's no civil judge junior division, you may be correct. So it's not just because that even if there is no senior judge, civil judge junior division, you cannot accept it. You cannot claim that.
Yes, sir.
But if there was a junior judge, junior division, civil judge junior division, what's the question of you are accepting it? What's the question you're filing before that? Because everyone has been given a jurisdiction. So these are the situation. It's not, I'm not saying that, I may agree with you that civil judge senior division cannot accept any suit, whatever may their value, because he has no limited jurisdiction. In the absence of junior division, he definitely can.
Yes. But my understanding
And finally, subject to final determination, this will not bind on this court. It's not binding on this court.
I am not on it.
Only persuasive
Yes,
value.
ma'am. My
We may learn from him.
Yes. This is what my
We may learn from the.
But that's why there is series of judgment. Where it says, my lord, that the lower court, the higher court, if they take up the matter. Now the another issue. Here is the case, my lord, that first point, timely objection was not taken. Second point, failure of justice, miscarriage of justice has not been pleaded, my lord. In that case, my lord, that is also point.
Yes.
Now, my lord, I will come to the point, my lord. Return of claim, not obligatory. This is very, now this will make it clear now. Now it's saying, section, this. From Jammu and Kashmir.
Give the Supreme Court judgment.
I will come on that point.
Come straight
So
to that.
things, my lord, these small things didn't reach to the Supreme Court. Most of the thing in High Court itself is. I will come. What are the dates? My lord, these things I will say there are 5. Why I'm saying, my lord, this is why important, my lord. I will show, my lord. Para three, man. Para three. Why I am showing this one? Now again the issue raised here is something like that. Now senior judge,
There are three.
para three. Here is the case is madam, it happens. Senior division entertain the matter. Now the issue raised is that why you have not returned the matter. Now the High Court is saying it's up to him. There is no obligation he has to return. If he prefers to continue with the suit, he can do it, madam. This is the ratio. May I return? One customer has submitted the trial court was not justified in returning the claim and direction itself should be filed in the court of subject in terms of section 15 of the decision. I find for in the argument of Mr. Thakur as the provision of section 15 of this civil procedure code regulate the procedure and do not prescribe or take away the jurisdiction. The purpose and objective of the section is that the court of higher grade should not be burdened or overcrowded with suits which can be entertained and adjudicated by the court subordinate to such court. This section will not deprive court of higher grade of its jurisdiction, which it otherwise possesses with respect to the subject matter. The institution of a suit in a court of higher grade, which ought to have been instituted in the court of lower grade, is only an irregularity in procedure matter and does not affect the jurisdiction of the court. The word shall used in this section is imperative on the suitor and not on the court. The suitor is obliged to bring its suit in the court of lower court competent to try it, and the provision is made for the benefit of the court of the higher grade. If the court of the higher grade does not wish to try the suit, it may refuse to entertain it. But if it wishes to retain the suit, it may do so. Under such circumstances, it cannot be said that court of higher grade has no jurisdiction to try the suit, though the same, as a matter of policy and procedure, ought to have been filed in the court of lowest grade. The higher court, in its discretion, may return the same for its presentation in the proper court. However, if such a suit is instituted in the lower court, then the one which is competent to try the proceeding shall be null and void, as being without jurisdiction. But if it is filed in the lower court, it will be null and void. And material prejudice has to be assumed to have been caused to be considered. Once the institution of the suit takes place, according to the provision of section 15, its operation is exhausted and suit should not be transferred merely because it is subsequently found that the same should have been instituted in the court of lowest grade. The court of higher grade of jurisdiction are advised to satisfy themselves about the valuation of the suit at the first instance and pass appropriate orders regarding their transfer as contemplated so and so. But once a higher court of jurisdiction take cognizance, it could not hold that same was without jurisdiction, even though the order of court below in directing the return of the claim may not be legal. Yet under the circumstances was not justified, particularly when he had taken cognizance, granted the interim relief, prima facie considered the rival claims of the party, and adjudicated upon the petition for the grant of the interim. This is exactly the by case. Now I'm not saying whether this is binding or not. This is for persuasive. Now
Yes, if it is filed before the lower court, having no jurisdiction, then only it will be null and void. But if it is in the higher court,
No issue.
it's up to the higher court.
Well, this clarity I came recently only. This is after reading because Mumbai High Court other decision is also the same line. I think our.
There are so many, there are so many decisions,
Yes.
separate high court. Why this case should not go to the Supreme Court?
I have tried my best. Let's see, madam, some
You,
other.
you
other
find
issues.
it, find out.
Yes. Now, madam, this is the understanding is stated. Even return of suit is not made. Now say that higher court once taken the matter cognizant. My case is also, his order has been passed. This is under challenge under FAO. Then my lord, this issues is yet a stage of framing of issue matter is there. Now, matter is proceeded. Unless failing to justice not shown, otherwise saying that, I am saying my lord, that the senior division has a jurisdiction. Because our act also has said, no way said, unlimited jurisdiction. Now with this, my lord, let's read out my lord, section 21 CPC and Suit Derivation Act. This is also important provision, section 21 CPC. Objection, I have already read
445.
Suit Derivation Act.
445.
I will try, at least division will try to finish the.
What has to be decided together? Taken up together.
My lord,
We'll continue tomorrow. What do you say? Yes. Can we continue tomorrow?
Tomorrow, my lord, it should be not possible. Today, I have postponed my journey.
Then after 24. Day after from the. I'll be available on 24th only. If it's not possible tomorrow. Well, keep it part heard. In any case,
This up to me,
no,
sir.
no, this,
No,
it has to be the disposed of along with this. This has to be decided. FAR. It has to be decided together.
this is the route, man.
Huh?
If anything is decided here,
Hmm.
it will be ultimately followed with this. Therefore, I have said this is the route, my lord.
Okay. Otherwise, we could continue tomorrow.
No issue. What
Tomorrow.
what can be done? Tomorrow, let me, because he has made his argument. Let me complete my argument tomorrow. Then if he has anything to say, he can. Otherwise,
on-
there is no such issue, my lord. Only the issue whether when the.
No,
report-
it's
senior court
no,
has-
no. Interesting issue has cropped up
Yes.
in view of the judgment of the Bombay and the Jammu and Kashmir
Yes.
High Court. No doubt it's not binding us. I have delivered a judgment recently also that there are lots of contradictory judgment all over the country for High Court. So certain cases, if it is taken to the Supreme Court, is for all of us, for litigants, lawyers and the judges of the High Court. But there is still so many cases where there is a contradictory view on the issue. But since it doesn't go to the Supreme Court in some cases, it remains the same thing. So it's not binding on us again. So we have, we apply our mind, we decide our own.
I have GLR report, our own High Court report. also.
Hmm.
This matter.
In our state also so many things to be, my lord. In respect
So
of
we'll
law.
continue tomorrow. In any case, we will not be able to complete today.
Only my
Tomorrow-
law point I have to only.
But tomorrow I'll continue hearing him.
Yes.
Then we'll fix the matter on 24th or 25th
My
of
lord.
September. Because till 23rd, I'll not be here.
23rd.
23rd, I'll not be here.
24.
24, no issue.
25 or 25th or 26th, we may continue.
25, 26. Tomorrow I will complete my only my lord, I have to give the citation.
No, we'll hear you everything.
My lord, this is important.
Since you are taking it up, we'll take it up on 25 only.
25th.
We'll not fix it tomorrow. All right, or we'll continue because he'll not be there.
Tomorrow I'll be not.
he may have a complaint, objection. That without his absence, we have heard you. Heard Mr. Sonat. Heard Mr. We'll continue.
Yes, my lord will be determining even 27 under such situation is that's a very important issue.
So once we decide this,
Yes.
it depends, the decision, it depends on FAO. If it is allowed, according to if it's allowed, the revision is allowed.
FA
Appeal
also
goes-
merge with this.
Merge with that. If it is rejected, then
Then FAO stands.
FAO has to be heard.
FAO has to be heard.
So in that
Correct.
case, we'll hear this first, then we'll hear this, we'll not hear this.
This decision will be hearing on that.
So we'll see on 25.
25.
We'll somehow we'll try to complete this.
Yes.
All right. And then it depends. If it is allowed, it merges along with this. If it is rejected, we'll have to hear it separately. Isn't it? On its own merit. Okay. Heard Mr. Do we agree that he should continue his submission tomorrow? Again, would you like to reply again in this?
In this, of course, my lord. Now also I have noted some.
Yeah.
Region that I have some
Then
noted.
it's of no use. I will also forget you all of you
Well, my
also.
lord, factual nothing is there. Tomorrow only, my lord, I have to present law on only. Nothing is there. Law is law, my lord.
No, he said.
His understanding of law
It's
will
okay.
differ my lord's
No,
understanding.
it's okay. It's okay. Because he would like to be there only.
If
Nowadays,
my lord, if he insists
this facilities also there. He can see from anywhere. my lord.
on the journey, I'll be in my
Because law point-
driving the bike.
law point, my lord, is something like.
It's okay. We'll continue on 25. Don't put pressure on me also. Heard Mr. K. Tama, London Council for the petitioners. And also Arson Learned Council for the respondents. Hearing two. Hearing to continue on 25th, 09/2024. 25th or 26th? 25th. No, this will be hearing to continue. It will listed. You remind me on that day. We'll take a. Why?
This is supposed to be.
It listed an admission only. Yeah.
This is the order. My lord has already passed the order.
So you see the yesterday's order?
Yes.
Yeah, this is already there. Listed for admission hearing tomorrow. Admission materials. You just write, hearing of the matter shall continue on 25th. Huh? On 25th. Got it? You change that. You just said heard so and so, so and so. Huh? Hearing of the matter shall continue on so and so, so and so. We'll just say, we'll not just make it part also.